So it's important to distinguish the two cases here. One dealt with raw cannabis, in which there was certainly no testimony that the smell came from the person. The officer testified that it came from the car. The second case dealt with smoked cannabis, which I think is probably closer to your hypothetical, which raw cannabis would lead a reasonable person to suspect a violation of the odor-proof requirement found in the vehicle code, because necessarily the smell of raw cannabis emitting from a vehicle is not being carried in an odor-proof container. It's obviously proof that there's cannabis in the vehicle, and then that you can smell it is indication that it's not being transferred or transported in an odor-proof container. There's no testimony that it is impossible to comply with the odor-proof requirement provision, and that's clearly not the legislature's belief, because they enacted the odor-proof requirement in 2019 at the exact same time that they put in place the now full legalization system.
It's called the plain sense doctrine, which is you have to plainly sense, see, hear something for there to be probable cause. Smell is not like that. You can't take a picture of a smell like you can objects that you see in plain sight. You can't record on an audio a sound you might have heard, for example, someone showing evidence of impairment. Smell is entirely subjective.
To deny the motion to suppress would place a citizen in the untenable position of exercising his rights under the Cannabis Regulation and Tax Act while forfeiting his rights under the Fourth Amendment of the United States Constitution and Article 1, Section 6 of the Illinois Constitution.